Get ready for the dictation in 3, 2, 1, start. This review petition has been preferred by the original writ petitioner seeking review of the order passed by this court in WPC number 4695/2020, which was preferred as a PIL for the benefit of advocates. Stop. The writ petition was dismissed vide our order dated 29th July 2020. Stop. Having heard the petitioner in person and looking to the facts and circumstances of the case, we see no reason to entertain this review petition, mainly for the reason that there is no error apparent on the face of the record in our order dated 29th July 2020 in WPC number 4695/2020. Stop. Much has been argued out by the review applicant party in person about the previous orders wherein notices have been issued by this court in matters pertaining to creation of the post of Advocate General in Delhi, selection process for the students, etc., which are annexed as annexers to the memo of the review petition. Stop. We have perused those annexers. Stop. The present case is a PIL preferred by the party in person for including advocates in the definition of the word professional under the Micro, Small and Medium Enterprises Development Act 2006. Stop. We are of the view that the advocates are capable of filing their own litigation if they wish to do so. Stop. On this point itself, we have dismissed the writ petition as a PIL. Stop. In the case of Meera versus Nirmala Kumari, reported in 1995, 1 SCC 170, the Honorable Supreme Court at para 8 and 9 held as under. It is well settled that the review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of Order 47, Rule 1 CPC. Stop. In connection with the limitation of the powers of the court under Order 47, Rule 1, while dealing with similar jurisdiction available to the High Court, while seeking to review the orders under Article 226 of the Constitution of India, this court, in the case of A. Sharma versus P. Sharma 1979 for SCC 389 AIR 1979 SC 1047, speaking through J. Reddy, has made the following pertinent observations. It is true, as observed by this court in Shivdev Singh versus State of Punjab AIR 1963 SC 1909. There is nothing in Article 226 of the Constitution to preclude the High Court from exercising the power of review which inheres in every court of plenary jurisdiction to prevent miscarriage of justice or to correct grave and palpable errors committed by it. Stop. But there are definitive limits to the exercise of the power of review. Stop. The power of review may be exercised on the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of the person seeking the review or could not be produced by him at the time when the order was made. It may be exercised where some mistake or error apparent on the face of the record is found. It may also be exercised on any analogous ground. Stop. But it may not be exercised on the ground that the decision was erroneous on merits. Stop. That would be the province of a court of appeal. Stop. A power of review is not to be confused with appellate power, which may enable an appellate court to correct all manner of errors committed by the subordinate court. Stop para. Now, it is also to be kept in view that in the impugned judgment, the division bench of the High Court has clearly observed that they were entertaining the review petition only on the ground of error apparent on the face of the record and not on any other ground. Stop. Thank you.